The Orbix Media team will continue to bring you the latest developments as they unfold.
All rise. The bailiff's command echoed through Federal Courtroom 24 as Judge Richard Leon stormed in, his face like thunder. Known as the Hammer for his brutal questioning and zero tolerance for unprepared attorneys, Leon had destroyed legal careers with a single sentence. Today he seemed particularly irritated. The Wilson voting rights case, he snapped, glaring at the packed gallery. Let's not waste time. The state's attorney rose confidently, expecting an easy win. The government rarely lost these cases. Then Jasmine Crockett stood up. No one expected much. At 38, facing a legendary judge in her first major federal case. Most onlookers gave her no chance. The odds were stacked impossibly against her and the thousands of minority voters she represented. Crockett approached the podium with a single manila folder. No paralegal team, no stacks of documents, just that one folder. Opposing counsel smirked visibly. Judge Leon's eyes narrowed with impatience. Then she spoke her first sentence. The courtroom froze. Judge Leon's expression transformed instantly. He leaned forward, completely focused on Crockett's words. The government attorney's smirk vanished. Spectators exchanged shocked glances. No one had ever seen the notoriously tough judge react this way. Your Honor, Crockett continued, pulling a document from her folder that no one knew existed. Before I continue, I'd like to submit evidence that will change everything we thought we knew about this case. The document she revealed would not only shock everyone in that courtroom, but potentially reshape voting rights cases across America for decades to come. If you want to know what was in that document and how it left the Hammer himself speechless, hit that like button and subscribe right now. What happens next will absolutely stun you. The case of Wilson versus State Election Board began when new voter ID laws effectively blocked 100 citizens from casting ballots in the last election. Unlike previous voting restrictions, these regulations appeared neutral on paper, requiring specific government-issued photo identification that most Americans take for granted. The problem in targeted districts, DMV offices had been closed, reduced to limited hours, or relocated miles away from public transportation. Getting the required ID now meant taking unpaid time off work, arranging childcare, and traveling distances that could reach 40 kilometers each way. The impact was devastating. In Westwood County, voter turnout dropped 63% after the new laws. In predominantly minority districts like Eastern Heights, some polling stations reported turning away hundreds of longtime voters whose IDs no longer qualified. Senior citizens who had voted for decades suddenly found themselves disenfranchised because their expired driver's licenses were no longer acceptable. I voted in every election since 1964, 78 year. Old veteran James Wilson told reporters outside the courthouse. Fought for this country, paid taxes all my life, and now they tell me my VA card isn't good enough to vote. Something's not right about that. Wilson became the lead plaintiff after walking 3 miles to his polling place only to be turned away. Judge Richard Leon wasn't just any federal judge. At 72, he commanded universal respect and fear in legal circles. Appointed by President George W. Bush in 2002, Leon had built a reputation as fiercely independent and unpredictable. He famously ruled against the NSA phone surveillance program, calling it almost Orwellian, yet had upheld controversial detention policies. Attorneys preparing for his courtroom studied his rulings obsessively, knowing he followed no predictable ideology except rigorous legal reasoning. Law clerks called him the Hammer because of how he demolished poor arguments. If you come unprepared to Leon's courtroom, one veteran attorney warned, you might as well just forfeit the case. His legendary memory for case law meant attorneys couldn't get away with misrepresenting precedents. Several had been publicly reprimanded for trying. Across from this intimidating figure stood Jasmine Crockett, whose journey to this moment defied all odds. Raised in South Detroit by a postal worker mother who sacrificed everything for her education, Crockett had worked night shifts through college and law school. Unlike the elite attorneys usually seen in federal court, she'd spent her career representing people who couldn't afford big firm lawyers. Before taking this voting rights case, Crockett had built a reputation defending wrongfully accused clients in criminal courts. Her unorthodox approach combined meticulous research with a streetwise instinct for finding evidence others missed. She'd won a landmark case freeing Marcus Williams, a man wrongfully imprisoned for 12 years after discovering police misconduct evidence buried in thousands of department files. What made this case extraordinary wasn't just the stakes. It was the David versus Goliath matchup. The state had deployed a team of 6 attorneys from one of Washington's most powerful firms with a combined legal experience of over 120 years. Their lead counsel, Bradley Thompson, had argued before the Supreme Court 7 times and never lost a voting rights case. His team had submitted a 378-page brief attacking Crockett's arguments from every angle. Crockett stood alone with a brief just 42 pages long. What observers didn't know was that Crockett's strategy departed radically from conventional civil rights litigation. While most voting rights attorneys relied on broad constitutional principles and emotional appeals, Crockett had spent 6 months building her case differently. She'd visited every affected community, collecting 358 first-hand accounts from voters who'd been turned away. She'd analyzed dim locations against census data, creating detailed maps showing the disparate impact. Most crucially, she filed Freedom of Information Act requests that yielded thousands of internal government emails about the new ID requirements. For 3 weeks, she'd worked 18-hour days in her small office, personally reviewing 11,842 documents. Deep in those files, she'd found something that no one, not even the government attorneys, knew existed. The courtroom that morning was packed to capacity. Civil rights leaders sat shoulderish, older with ordinary voters whose rights hung in the balance. National media filled the press section, sensing this case might set precedent for similar laws in 17 other states. As Judge Leon called the court to order that morning, no one imagined they were about to witness one of the most extraordinary legal confrontations in recent memory. One that would not only decide the fate of hundreds of thousands of voters, but potentially reshape how courts evaluated voting rights cases for decades to come. Have you ever faced obstacles trying to vote? Were polling locations convenient in your community, or did you face challenges? Share your experience in the comments. Understanding real voter experiences helps us see how these cases affect everyday Americans. The courtroom buzzed with tension as the bay called for order. All rise. The United States District Court for the District of Columbia is now in session. The Honorable Judge Richard Leon Preeding. Judge Leon entered, his black robe flowing as he took his seat at the bench, his piercing gaze surveyed the packed courtroom before landing on the attorneys' tables. "You may be seated," he said, his voice resonating with authority. "We're here today for oral arguments in Freedom Access Project versus Brennan Election Commission. Ms. Crockett, you may proceed." Jasmine Crockett approached the podium with measured steps, the clicking of her heels against the marble floor, the only sound in the silent courtroom. She placed a single binder in front of her, though she would rarely refer to it. "Thank you, Your Honor," she began, her voice clear and steady. "This case centers on a fundamental question. Can a state implement voting regulations that are facially neutral but have a demonstrably discriminatory effect? The Supreme Court has repeatedly held that the right to vote is preservative of all other rights. When that right is compromised, our entire democratic system is weakened." She paused, making eye contact with Judge Leon, who was already leaning forward slightly. "The state argues that these new identification requirements are necessary to prevent fraud. Yet, in the 10 years before these regulations were implemented, there were exactly 7 cases of in-person voter fraud out of more than 14 million votes cast. That's a fraud rate of 0.00005%. Judge Lean interrupted as was his custom. Ms. Crockett, fraud prevention is a legitimate state interest regardless of how rare fraud might be. The Supreme Court acknowledged as much in Crawford v. Marion County. This was the moment when most attorneys would become defensive or backpedal. Crockett did neither. "You're absolutely right, Your Honor," she replied, surprising him with her immediate agreement. Crawford did establish that fraud prevention is a legitimate state interest. However, Crawford also established a balancing test that weighs that interest against the burden placed on voters. She pulled out a map and requested permission to approach the bench. "With the court's permission, I'd like to show you something." Judge Lean nodded and Crockett unfolded a large detailed map of the state with various colored overlays. This map shows the impact of the new regulations. The red areas indicate communities where more than 30% of eligible voters lack the newly required ID. The blue dots represent DMV offices where voters can obtain this ID. As you can see, in the heaviest red areas, there are virtually no blue dots. Judge Leon studied the map with furrowed brows. "And your point, Counselor, my point, Your Honor, is that for voters in these areas, predominantly minority communities, obtaining the required ID means traveling up to 175 mi round trip. For those without cars, that's a 3-hour bus journey each way, if bus service is even available. The DMV offices in these areas are only open 2 days per week from 9:00 a.m. to 4 p.m. hours when most working people cannot visit without losing a day's wages." The state's attorney, Michael Reynolds, stood up. "Objection, Your Honor. The inconvenience of obtaining ID doesn't rise to the level of a constitutional violation." Judge Leon turned to Reynolds with a stern expression. "This isn't a trial, Counselor. Save your objections. You'll have your turn." He turned back to Crockett. "Please continue." Crockett nodded. "Thank you. Your Honor, the Supreme Court in Harper v. Virginia Board of Elections established that a state cannot impose a cost on the right to vote. While the state isn't directly charging for the ID, the economic analysis we've submitted shows that the average cost in lost wages, transportation, and obtaining underlying documentation like birth certificates amounts to approximately $175 per voter. She continued methodically building her case brick by brick, anticipating and addressing potential counter-arguments before Judge Leon could even raise them. For almost 40 minutes, she navigated through complex legal doctrines, weaving together precedents from voting rights cases spanning decades. Judge Leon, normally quick to interrupt with challenging hypotheticals, found himself listening more than speaking. When he did pose questions, they were met with precise, thoughtful responses that showed a depth of preparation rarely seen in his courtroom. Then came the moment that would shift the entire trajectory of the case. Judge Lean posed what many considered an impossible hypothetical. "Ms. Crockett, let's assume the state implemented a voting system where every citizen was assigned to a polling station based on the last 4 digits of their social security number. If it turned out this seemingly neutral system resulted in minority voters having to travel twice as far on average without any evidence of discriminatory intent, would that violate the Constitution?" The courtroom held its breath. This was the kind of complex legal puzzle that had tripped up countless attorneys in Judge Leon's courtroom over the years. Crockett paused, considering the question carefully before responding. "Your Honor, that hypothetical directly parallels the Supreme Court's reasoning in Gillian v. Lightfoot, where a facially neutral municipal boundary that excluded 99% of black voters, but no white voters were struck down despite using geography rather than race as the criterion." She wasn't finished, but your hypothetical actually highlights something more fundamental about this case. The state is essentially arguing that as long as they don't explicitly mention race in their regulations, any disparate impact, no matter how severe, is constitutionally permissible. She then made a surprising pivot that caught everyone off guard. "Your Honor, may I approach again? There's something specific in the evidence that directly addresses your hypothetical." Judge Leon, clearly intrigued, nodded. Crockett retrieved a document from her table and handed copies to the judge and opposing counsel. This is an email exchange between the Commissioner of Elections and the consultant who designed these new ID requirements. On page 3, the consultant writes, and I quote, "The beauty of using these specific criteria is that they disproportionately impact demographic group while giving us complete deniability since they never mention race directly." A murmur ran through the courtroom. Judge Leon's eyebrows rose as he examined the document. "And how did you obtain this email, Miss Crockett?" he asked. "Through standard discovery. Your Honor, it was among the 50,000 documents provided by the state. I suspect they didn't expect anyone to find it. Buried as it was in technical appendices about database management." The state's attorney was frantically flipping through his own copy, his face growing pale as he located the damning passage. Crockett continued, "This isn't just about disparate impact, Your Honor. This is about intentional discrimination hidden behind a veneer of neutrality. The Supreme Court in Arlington Heights gave us the framework for identifying exactly this kind of pretextual discrimination." The atmosphere in the courtroom had transformed. Where there had been the typical formal tension of legal proceedings, there was now an electric sense that history was unfolding before everyone's eyes. Judge Leon studied the email evidence with intense concentration, occasionally looking up at Crockett with an expression that shifted from skepticism to something rarely seen on his face. "Growing respect, Miss Crockett," he finally said, "you've presented compelling evidence regarding intent. But even if we accept that these regulations were designed with discriminatory purpose, the state argues they have a compelling interest in preventing fraud that would survive strict scrutiny." This was the critical moment, the final hurdle Crockett needed to overcome. The courtroom fell completely silent, with even the court reporter seeming to hold her breath. Crockett's response came with quiet confidence. "Your Honor, for a law to survive strict scrutiny, it must be narrowly tailored to achieve a compelling government interest. These regulations fail that test for 3 reasons." She held up one finger. "First, they are not narrowly tailored. Our expert analysis shows that 94% of the burden falls on minority communities while addressing a problem, in-person voter fraud, that essentially doesn't exist statistically. A second finger, second, there are numerous less restrictive alternatives that would achieve the same anti-fraud objective without disenfranchising legitimate voters. We've detailed 16 such alternatives in our brief." A third finger. "And finally, the email evidence shows that fraud prevention was not the true motivation behind these regulations. The court has consistently held that pretextual justifications cannot satisfy strict scrutiny." She then revealed what would become the most discussed moment of the entire proceeding. "Your Honor, with the court's permission, I'd like to introduce one final piece of evidence that we only obtained yesterday." Judge Leon nodded, and Crockett handed a sealed envelope to the clerk, who delivered it to the judge. As he opened it, his expression changed dramatically. Inside was a confidential memorandum from the Election Commission's own security team dated just 2 weeks before the new regulations were announced. It explicitly stated, "After comprehensive review, we find no evidence that in-person voter impersonation presents a significant security risk to election integrity. Resources would be better directed toward addressing actual vulnerabilities in the election system, particularly in the area of cybersecurity." Judge Leon looked up, his eyes wide. This directly contradicts the state's central claim about the purpose of these regulations. "Yes, Your Honor," Crockett replied. "The Commission ignored its own security team's findings because the true purpose of these regulations was never about fraud prevention." The state's attorney, Michael Reynolds, jumped to his feet. "Your Honor, we've never seen this document. We object to its late introduction." Judge Leon fixed Reynolds with a stern gaze. "Mr. Reynolds, this appears to be your client's own internal memorandum. Are you claiming the Commission withheld it during discovery?" Reynolds faltered. "I would need consult with my client." "Your Honor, I suggest you do that immediately." Judge Leon replied, his voice ice cold. This court takes discovery obligations very seriously. He turned back to Crockett, studying her with a new intensity. The entire gallery could sense something unusual was happening. Judge Leon, known for his poker face during arguments, was visibly impressed. Miss Crockett, Judge Lean said, his voice carrying through the hushed courtroom. In my 30 years on this bench, I have never witnessed legal reasoning of this caliber. You've just changed the entire framework of how we should examine this case. The statement sent shockwaves through the courtroom. Legal observers would later comment that they had never heard Judge Leon offer such direct praise during proceeding. But what happened next truly electrified the room. Instead of simply acknowledging the compliment, Crockett responded, "Thank you, Your Honor. But this case isn't about legal reasoning or attorney performance. It's about the fundamental right of every American citizen to cast their vote without facing artificial barriers designed to silence their voice. The 150,000 voters who have been effectively disenfranchised by these regulations deserve this court's protection far more than I deserve any praise." The response redirected attention from her personal achievement back to the constitutional principles at stake. Several people in the gallery nodded in silent approval. Judge Leon leaned back slightly, a rare smile briefly crossing his face. "Well said, Counselor. Well said indeed." He then turned to the state's attorney. "Mr. Reynolds, I suspect you have your work cut out for you. You may proceed with your argument." Reynolds approached the podium, looking visibly shaken. His confidence had evaporated as he shuffled through his notes, trying to regroup. "Your Honor, while a mess, Crockett's presentation was certainly impressive. She fundamentally mischaracterizes the state's position and the applicable law. His argument never gained traction." Judge Leon interrupted repeatedly with pointed questions that revealed he was viewing the case through the framework Crockett had established. "Mr. Reynolds, how do you reconcile your fraud prevention argument with your own security team's memorandum stating that in-person fraud is not significant risk? How do you explain the email explicitly discussing using neutral criteria to target specific demographic groups given that only 0.05% of votes involved alleged fraud? How is this sweeping regulation that affects 17% of eligible voters narrowly tailored?" Reynolds struggled to provide convincing answers. By the time he concluded his argument, the outcome seemed increasingly clear to everyone in the courtroom. When Crockett rose for her brief rebuttal, she spoke with quiet conviction that resonated throughout the chamber. "Your Honor, this case ultimately isn't about complex legal doctrines. It's about whether our Constitution permits the government to create a system where some citizens must overcome significantly greater barriers than others to exercise their most fundamental right in a democracy. The evidence and precedent before this court provide a clear answer. It does not." As she gathered her materials and returned to her seat, the courtroom remained silent. Everyone sensing they had witnessed something extraordinary. Not just brilliant legal advocacy, but a pivotal moment in the ongoing struggle to protect voting rights. The impact of that historic courtroom confrontation reverberated far beyond the walls of the courthouse as Jasmine Crockett descended the courthouse steps after the hearing. She was met by a sea of reporters and cameras, all eager to capture her reaction. "Ms. Crockett, CNN here. What was your reaction to Judge Leon's unprecedented compliment?" She paused thoughtfully before responding. "What matters isn't any compliment to me, but whether the court upholds the constitutional rights of the voters who have been silenced by these regulations. This case has always been about them, not about any individual attorney." Her response was widely praised for redirecting attention to the substantive issues at stake rather than personalizing the victory. Behind the scenes, the state's legal team was in crisis mode. Multiple sources reported that emergency meetings were convened to discuss a potential settlement before Judge Leon could issue what many now expected would be a scathing ruling against them. Legal experts across the political spectrum recognized the significance of what had transpired. Harvard law professor Lawrence Tribe tweeted, What Jasmine Crockett accomplished today wasn't just brilliant advocacy. It was a masterclass in constitutional litigation that will be studied in law schools for years to come. Even conservative legal scholars acknowledge the power of her presentation. Former Solicitor General Paul Clement noted on a legal podcast, regardless of where you stand on the underlying issues, the quality of advocacy displayed by Ms. Crockett was exceptional by any standard. She systematically dismantled the state's position with precision and remarkable command of both precedent and factual evidence. 3 weeks later, Judge Leon issued his ruling. In a comprehensive 87-page opinion, he granted a preliminary injunction blocking the implementation of the voting regulations. The opinion began with unusual directness. This case presents a textbook example of regulations that, while facially neutral, were designed with a specific intent to limit the voting rights of minority citizens. The evidence of discriminatory intent is overwhelming, and the state's justifications cannot withstand constitutional scrutiny. Judge Lyon's opinion established a new framework for evaluating voting regulations that had disparate impacts on minority communities. When a voting regulation imposes substantial burdens that fall disproportionately on minority communities, courts must look beyond mere assertions of legitimate purpose. Evidence that officials were aware of and intended such disparate impacts, whether from communications, statistical analyses, or contradictions between stated justifications and internal assessments, can establish unconstitutional discriminatory intent, even absent explicitly racial language. The ruling sent shockwaves through state legislatures across the country. Within days, officials in 5 other states with similar pending regulations announced they were reconsidering their approaches. Voting rights advocates in a dozen states filed new legal challenges to existing regulations, citing Judge Leon's opinion as persuasive precedent. For the thousands of affected voters, the impact was immediate and concrete. The state was ordered to suspend the ID requirements and develop a new plan that would ensure equal access to the polls for all eligible voters. In the next election, turnout in previously affected communities increased by 31%. 2 months after the ruling, Jasmine Crockett was invited to give the keynote address at the American Bar Association's annual Civil Rights Conference. Her speech, titled "Constitutional Advocacy in the Modern Era," would later be required viewing in law schools nationwide. "The Constitution's promises aren't self-executing," she told the packed auditorium. "They require advocates willing to do the painstaking work of connecting abstract principles to lived realities. When we allow procedural technicalities to overshadow fundamental rights, we betray the document we claim to revere." She concluded with words that would be quoted by future generations of civil rights attorneys. "The most powerful tool in constitutional advocacy isn't eloquence or ideology. It's preparation. The unglamorous work of mastering the facts, understanding the precedents, and anticipating every counterargument before you ever step into a courtroom. That preparation happens in quiet rooms with stacks of documents, not in front of cameras. But when the moment comes to stand up for someone's rights, that preparation becomes power." Perhaps the most meaningful recognition came from Judge Leon himself. In a rare post-decision interview with Legal Times, he was asked about cases that had changed his thinking about constitutional interpretation. "You know," he said thoughtfully, "judges are supposed to be influenced only by the law and the facts, but sometimes an advocate presents those elements with such clarity and precision that it illuminates constitutional principles in ways you hadn't fully considered before." The voting rights case, argued by Ms. Crockett, was such a moment. The most lasting impact wasn't felt in Washington, but in communities across America. In the years following Judge Leon's decision, states were forced to reconsider voting procedures that had created barriers for minority, elderly, and disabled voters. Access to the ballot expanded. Voter participation increased. The democratic process became more inclusive. Law professors now teach the case alongside landmark voting rights decisions. Constitutional law textbooks include excerpts from the oral argument and Judge Lyon's opinion. A generation of young lawyers study Crockett's techniques and approach. For Jasmine Crockett herself, the case became both a defining achievement and a launching pad for broader influence. She continued her civil rights work with a new level of national recognition, focusing on voting rights, criminal justice reform, and economic equity. Yet, she remained grounded in the communities she served. When asked by a reporter if she saw herself as a legal superstar after the case, she smiled and shook her head. "I see myself as someone doing the work that needs to be done. There are millions of Americans whose rights are vulnerable. My job is simply to use whatever skills I have to help protect those rights." The lesson of that extraordinary courtroom confrontation wasn't just about legal strategy or persuasive skill. It was about the power of meticulous preparation, moral clarity, and unwavering focus on fundamental principles. It was about the difference one person can make when they combine deep knowledge with passionate advocacy. For those who witnessed that historic day, the memory remains vivid. A hushed courtroom, a brilliant advocate, an impressed judge, and constitutional principles powerfully vindicated. For the thousands of voters whose rights were protected by the resulting decision, the impact continues in something more fundamental: the ability to participate as equal citizens in American democracy. If this story of exceptional legal advocacy inspired you, don't forget to like this video and subscribe to our channel. We bring you the most powerful moments from America's courtrooms that are shaping the future of our constitutional rights. Share this video with anyone who needs to be reminded that preparation and principle can still triumph in our justice.